again, Wes. So just by way of background, the Asia Pacific Interest Group is a collection of about 200 academics, lawyers, arbitrators, think tank specialists, policy experts, and so on, who focus on the Asia Pacific region in their work. And we're very fortunate to kick off a webinar series with this webinar on international law in Asia Pacific during the COVID-19 pandemic. This webinar is really an attempt to grapple with the widespread and manifold impact of COVID-19 in terms of what its effects on international law, both private and public, in the region of the Asia Pacific. Intentionally, the webinar is quite broad in its scope. We are going to be examining the diverse effects across a number of jurisdictions in the region. In subsequent webinars, we will focus on more specific problems and topics. So we can think about some of these effects in a number of ways, and I just wanted to highlight three kind of buckets or categories of potential effects. This is obviously a non-exclusive list. So the first is the relationship between domestic law and international law. And as states roll out emergency legislation at the domestic level, there's the possibility that that legislation will create friction with treaty obligations. And here we can think about concerns such as fair trial, freedom of movement, and other human rights. So that's number one. Number two is in the area of private international law. Obviously, commercial transactions cross-border have been massively hit by the pandemic. Disputes have increased. And also disputes are evolving. The nature of dispute resolution is evolving with the pandemic as we see more online, virtual, or digitized forms of disputing. The third kind of bucket or category is the role of international organizations and global health governance, particularly under the stress of the existing US-China trade war and other tensions in the world system that put strain on multilateral institutions. So we have very different views of the WHO, for example, from the perspectives of DC and Beijing. So there's a rich set of issues for us to parse. I want to move now to introducing our excellent speakers. So beginning with Professor Vivienne Bath from the University of Sydney. Next, Professor Manjiao from University of International Business and Economics, based in Beijing. Mr. Kawun Kakar of Kakar Advocates in Kabul. Next, we have Mr. Ali Sultan from the Research Society of International Law. Next, we have Charis Tan from Peter and Kim in Singapore. And then last but not least, Professor Weixia, and also the co-chair of the Asia Pacific Interest Group, based at the Hong Kong University Faculty of Law. And now, without further ado, I want to allow our first speaker, Professor Vivienne Bath, to kick us off. Vivienne, over to you.
Thank you, Matthew, and thank you very much to Wes and ASIL for setting this seminar up. I've done very well on the time zone, of course, because it's 10 a.m. in the morning here, so at least I'm fairly compos mentis. I'll start briefly with an overview of the effect of COVID-19 on Australia and I suppose New Zealand. We had the advantage of being islands or a collection of islands, and also of having governments that responded very quickly to expert advice in relation to handling the pandemic. So we have been more or less in isolation from the rest of the world since essentially February, first in a very harsh lockdown and now in a less restrictive lockdown, although we're having a few cluster outbreaks at the moment as a result of some very enthusiastic opening up, mainly by the younger generation. But in terms of handling the pandemic, we've done fairly well. Borders are still closed. The numbers of Australians even who can come back are quite restricted. And during this period, despite our success with the epidemic, the economy, of course, is looking in very poor shape due to the number of people who are unemployed and the loss of opportunities for people to essentially find new work. And at the international level, despite the fact that we're fairly isolated, our relations, particularly with China, seem to have been in steady decline ever since the beginning of February, when Australia closed its borders to Chinese visitors, which hit, of course, the university sector very hard because the great mass of Chinese visitors in February are Chinese students coming in for the beginning of the semester at the end of February. So that's had a fairly disastrous effect on the universities generally. So I'll cover a few things quickly in relation to what's been happening in Australia in the international sphere. The first of these, of course, is the decision of the government to push very hard for an international investigation into the causes of the pandemic. China took this as a personal attack on China itself, which I don't think it wasn't intended to be, although I have to say it could have been handled better at a political level. Australia is committed to WHO, and ultimately a resolution was passed in relation to an investigation into the causes of the pandemic, but it has had a fairly unfortunate effect upon our relations with China. It was followed fairly shortly after by the imposition of very hefty anti-dumping duties by China on the import of Australian barley. It's not at all clear whether there was a relationship, but of course it's generally believed that it was. Another cause of international distress, I suppose you could say at the Australian level, is the new national security law in Hong Kong. Hong Kong is the home of the largest overseas batch of Australian expatriates. 100,000 Australians live and work in Hong Kong. And the government responded very badly to the Hong Kong national security law for obvious reasons. Quite recently, the government decided as a consequence of this that it would suspend the Hong Kong-Australia extradition treaty. Although the government website is not specific on the justification for this, the reason is, as you might expect, on the basis that the new laws represent a fundamental change of circumstances that undermine the one country, two systems framework that Hong Kong is governed under. It's a fairly old-fashioned extradition treaty, and it doesn't require the production of a great deal of evidence. So although there's an exception in the treaty for political offences, that is, we won't extradite people for political offences or prosecute or on the basis of prosecution by virtue of political opinions, the easiest way to deal with it, the government felt, was to suspend the treaty in its entirety. So it's been suspended for a period of 5 years. Termination would take a period of 6 months. Going back to the international level and trade, Australia has become a party to the multi-party interim appeal arbitration arrangement under Article 25 of the Dispute Resolution Understanding. This, of course, has been set up in order to deal with what one can only describe as the recalcitrance of the US in making it impossible for the appeal body, the WTO, to actually hear appeals. Australia is currently involved in a number of disputes at the WTO level. It's a complainant against India in company with Brazil in relation to the import of sugar and sugarcane. It's brought a case against Canada in relation to Canada's wine distribution arrangements. And it's a defendant in a complaint brought by Indonesia for the imposition of dumping duties on A4 paper. So presumably work on all of this continues, although progress obviously is slow. In relation to bilateral activity, Australia continues to be active despite COVID-19. We're negotiating a number of free trade agreements. The big one at the moment is the EU. But since January, 3 free trade agreements have actually come into effect. Now, the first of this is the free trade agreement with Hong Kong, which came into effect on the 17th of January 2020. There have been some calls for it to be suspended as well, but it doesn't seem very likely that that will actually happen. An agreement with Peru came into effect on the 11th of February 2020. Peru, of course, is likely to ratify the Comprehensive Partnership on the Trans-Pacific, the Comprehensive Progressive Trans-Pacific Partnership as its agreement, as it's called, that's TPP 11, but has not yet done so. But it has signed and brought into effect this FTA with Australia. And the most recent one, and the most significant one really from Australia's point of view, is the Indonesia-Australia Comprehensive Economic Partnership Agreement, which came into effect on the 5th of July 2020. So activities with our neighbours on that front continue to be active. Now, the last one that I want to talk about in terms of what Australia is doing goes back to the free trade agreements and changes in investment law. Now, on national security grounds, the government said they changed the provisions under the Australian Foreign Investment Law to require that all investments into Australia during this current period have to be reviewed by the Foreign Investment Review Board. Normally speaking, investment in Australia is fairly straightforward. If it's agriculture, there's quite a high level of review. If you're a foreign-owned government enterprise, a state-owned enterprise, then all of your investments are subject to review. And there are certain areas which are considered to be sensitive. And these include things like media, telecommunications, transport, and so on. But at the moment, if you want to do any acquisition in Australia, or if you want to make any investment into Australia, then you have to actually have your entire investment reviewed. As a result of this, the period for review has been extended to 6 months. The idea behind this apparently was that the government felt that this would, COVID-19, the drop in property prices, the lack of economic activity, would present opportunities for opportunistic buyers to snap up assets at a bargain price. I don't know whether there's any evidence that this was happening, but Australia, I think, is not the only country to express concerns along this basis. So these changes went into effect and are likely to stay in effect for some time. But they've also been the trigger for new provisions which are coming into place as a result of heightened sensitivity in relation to national security. And I think that this really has to be attributed to heightened pressures or heightened tensions within the Asia-Pacific region. And again, these relate mainly to China. There's China's activities in the South China Sea, which cause concern at the Australian level and of course for nations around the South China Sea. There's the increasingly aggressive comments by Chinese diplomats and commentators, which have caused a great deal of concern. There's been a lot of discussion in Australia about Chinese espionage and activities and the influence potentially of Chinese government agents in Australia. None of this is doing our relationship with China any good, I have to say. Now, as a result of this, and I guess as a result of increased attention to the question of national security, which seems to be a worldwide trend, the government has announced that investment laws will be changed in the long term, even after the current restrictions are limited, in order to provide for an enhanced national security review of sensitive acquisitions. And this relates to things like so-called critical infrastructure, defense installations, and so on. The reason for this really is something which we got ourselves into starting with the US-Australia Free Trade Agreement, where the US negotiated successfully for larger acquisitions to be possible without intensive government review. Over time, all of our free trade departments, including China, Korea, Japan, and other places, have also negotiated for these thresholds. So in most sectors, actually, you can invest in Australia up to $1 billion or buy companies of up to $1 billion with really only minimal review. The government's decided that in terms of sensitive infrastructure in particular, this is no longer desirable, telecommunications, power, etc. And so the provisions are being brought into place so that something which comes within these sensitive categories will be subject to review regardless. My time is up, my little buzzer has gone off. So thank you for the opportunity, and I'll stop now, Matthew.
Perfect. Thank you so much, Vivienne. Excellent on the time as well. So moving now from Sydney to Beijing, we now have Professor Manjiao. Professor Chi, please take it away.
Thank you, Matthew, and thank you to ASIL for having me here for this important meeting. Good morning from Beijing, Beijing time. First of all, I would try to explain why my picture looked a little bit strange, because my camera is not in the front position. So I have to shift my head a little bit so that I can be seen. So I don't get so much surprised of this strange position. This issue, COVID-19 issue, is really, I would say, at present day, probably nothing more important than this issue at the global level. First of all, as mentioned by Matthew, I would first outline a little bit about China and the COVID-19, and then a little bit international law perspective on that. So as probably everybody knows, China is the country with the first report of COVID pandemic. At that moment, it was not called pandemic. That was limited to China in Wuhan city, a central Chinese capital city of Hubei province, which is very populated, highly populated province in China in January. And then it spread to other parts of China. We find later on, we find other countries in the world also get this virus or COVID-19, and then became a pandemic. Even today, I have to say that the whole world is still struggling in this pandemic. As far as China is concerned, after January, China took very, very strict measures, emergency measures to combat COVID-19. We have social distance measures. Even today, social distance measures in many places have not been really lifted. And some of the cities already lifted social distance restrictions, but still the enforcement departments are still enforcing to certain levels social distance. Then economic lockdown, we see a huge scale of economic lockdown. This is probably the Chinese way, I'm not sure, but it also happened in many other parts of the world. We see the factories were shut down, shopping centers were shut down, everything. It's now recovering in China, but still I believe more time is needed, and depending on the places, in some of the places like in Beijing, now it's still struggling. But in other places, things are getting better. So we see the recovering of those economic lockdown measures. And then also some of the Chinese governments, local governments, and also central government as well, took certain kind of mitigation measures, try to reboom the economic development. The most important thing is about the tax incentive. Some of the governments provide certain kinds of tax incentives, try to create conditions so that companies, especially small and medium-sized enterprises, could resume their production. These companies actually were most severely hit by the COVID during the pandemic. So we see this is the basic picture. I have to say, probably at this point of time, China is not the country that is in the deepest crisis of COVID, but still it's very in the critical situation now. Vivienne also mentions from an international relations perspective, the COVID has changed China, the bilateral relations, and actually the relationship with all other countries in the world. We hear not only one country, but quite a few countries have already said that the relationship with China would not be the same had there not been the COVID. Of course, those were a very clear gesture that China is currently in a difficult situation, I have to say. There are a number of reasons for this. Aside from COVID-19 pandemic, I believe this is the immediate reason for this change of international relations with China. But aside from that, as Vivienne has also mentioned, there are, Matthew also mentioned as well, there are a few other major developments for China-US trade war, which has started 2 years ago. So that's already not something new. And then the recent Hong Kong national security law, I believe this is an important factor. But of course, that is important, but I'm not sure whether the national security law in Hong Kong is the same thing with COVID-19. And then South China Sea, we hear the declaration of U.S. State Secretary just I think it's yesterday from Beijing time. And a number of other things in China. Within China, we also have this the flood, and then the things are getting difficult for China. But let me just focus on COVID-19, which I believe is the theme of our meeting. So for COVID-19, I believe from international law perspective and also for domestic law perspective, I think there are a lot of implications. As far as in February, that's the China's Lunar New Year time, there are already quite a lot of reports saying that Chinese companies, they are engaging in foreign trade with European, US companies, and they are very difficult. They were very difficult because they could not enforce, or let's say they could not perform their contractual obligations because of these kind of social distance and economic lockdown. A very typical example is many of these companies, they cannot ship their products abroad because of the harbor, because of the transportation limits. That's something very difficult for Chinese companies. And then the government has taken some measures. One of the, I think it's probably a very helpful measure is the government issued the factual certificate of force majeure, which is not a legal conclusion that a situation does constitute a force majeure situation within the contract law, but it's a factual certificate. So with that factual certificate, I believe it seems easier for Chinese companies that claims force majeure situation, improving there exists such a situation. But of course, that's something more at the domestic law level. So different countries have different legal standards for establishing whether a situation is that force majeure. So that remains difficult for Chinese companies. But I believe the Chinese companies are not the only victims of this. So this is the first thing. And the second thing I think that is severely hit is the investment in China. We do have quite a lot of foreign investments in China, and actually after the China-US trade war, there were a lot of companies, they are moving out of China now, but because of the COVID-19 and then the recent tension between China and the US, more and more companies are leaving China. So they are going to Vietnam and other Southeast Asian countries instead. But for companies, they are in China, I believe that they have suffered a lot from the COVID-19. And then China, what I want to highlight is China has quite a lot of investment treaties with different countries. We have signed more than 130 bilateral investment treaties, BITs, with nearly 110 BITs are now in effect. So for foreign investors, it is possible for them to seek compensation if they believe or if they can establish that there is a violation of this treaty by China caused by the COVID-19 response. But presumably, I would say there are a number of these treaty provisions that could be related to this kind of situation. For example, there are some treaties, not so many, but around my rough calculation would be around 20 of these treaties with exception clauses. The exception clauses looks similar to either GATT 20 or 21 general exception or national security exception. So if if they have this, and then it's possible. And another thing is for fair and equitable treatment and indirect expropriation. So companies may also try to rely on this. Aside from foreign companies, there are a lot of Chinese companies abroad. It is also possible for Chinese companies to use these treaties to try to get compensation. So I notice my time is up, so I shall stop here. So I return the platform to Matthew. Thank you.
Thank you. Thank you so much, Manjiao. That was terrific and really fascinating set of questions that China is confronting at this moment. Now, if we could, I'd like to move from Beijing to Kabul, and Mr. Kawun Kakar, over to you, sir.
Okay. Well, thank you very much. It's a great pleasure to be participating with the other very new colleagues here. I would say first I'll start with some overview very quickly on the kind of the numbers. In Afghanistan, we have over 35,000 confirmed cases and close to 1,000 deaths. But the actual numbers are much, much higher. I'm thought to be much, much higher because there's just lack of widespread testing. And the healthcare system, as expected, is incapable to cope with this new pandemic. There are no signs of actually COVID being brought under control, especially since the country is mostly opened, except schools, universities, and some of the sporting events and others are restricted. There were attempted lockdowns for a couple of months at the beginning, although they were not uniformly or strictly enforced. The economic outlook is extremely grim. The World Bank actually came out with a report just 2 days ago, and it reported that the GDP will this year contract somewhere between 5.5 to 7.4%. The government revenues will be down by 1/3, according to World Bank, and according to IMF, perhaps as much as 1/2. And the poverty rate, according to the World Bank report, will be as high as 72%. So we're looking at some very grim numbers there. Some of the adverse effects of the COVID have been covered by some donor support. Afghanistan, as you, I'm sure, know well, is highly dependent on donor support for its economy and for its, and for the livelihood of the people. We had more than 500, but also increasing pledges from donors. $500 million. And first time, actually, one of the legislative actions that also took place was that a $200 million loan was approved from IMF. This was, I believe, the first time in a long, long time that the loan was approved or actually taken from foreign institutions. So reduced revenues, difficult circumstances, and still for the budget, of course, whatever of the budget is there, some of it is being reallocated for health and livelihood sectors. And the government is looking at ways on how it can support the population, especially the vulnerable population during this difficult time, especially as we see it, the situation seems like it will not turn around anytime soon. So all of this, if you're not depressed enough on top of, a brutal war that has been going on for decades in Afghanistan, and most recently also months of disputes over the results of the presidential election, which finally about 2 months ago resulted in an agreement between the two leading candidates. But we still do not have the full cabinet in place. None of the cabinet members has received the parliamentary vote of approval. And okay, the only some talks of peace that perhaps is something that could give some hope, but that has been also lingering for a while. So all of this, as you can imagine, unlike many of the other countries, here there's not been, I would say, limited legislative actions. I mean, the situation has not allowed for very active legislative actions. Nonetheless, on that front, if you come in on the kind of legal policy impacts of the COVID, Afghanistan is a landlocked country, so it's heavily dependent on trade. It imports a whole lot than it exports, so it relies mainly on ground and some air transportation for trade. At the beginning, movement of people and trade on the ground with neighboring countries were restricted, but at the beginning, actually, the only people that were, or things that were allowed in were the immigrants based in Iran and Pakistan. They were, many of them were, especially in Iran, they were no laborers. They were, they had lost their jobs and they were returning back to the country in large numbers. In fact, COVID, the first instances were discovered on our border with Iran in Herat through many of the immigrants that came through. At the beginning also, Pakistan imposed restriction on export of wheat to Afghanistan. I think Afghanistan imports the wheat from Afghanistan, from Pakistan. That resulted in, I would say, temporary price, increase in price of bread and food items. Now the prices have actually stabilized because Afghanistan is also able to import food products from other countries, but also the border with Pakistan has, the trade has normalized back, but after some major disruptions because I think there were new restrictions or the requirements for processing of goods for the trucks and others that were what would you hear for weeks being stranded on the other side and from being cleared through the border at the seaport in Karachi and beyond. So trade by air has resumed, but it's limited. Some flights from Turkish, they started, but now they have been also stopped because there were a high number of what was stated to be a high number of patients from going from this side. We have Qatar Airways that actually has started on no regular flights. That is something, but also the local internal the flights have begun, but international flights are limited. Overall, the trade has also suffered, perhaps beyond the restrictions, on the decreased purchasing power of the consumers in Afghanistan, and also on the kind of the high prices, and so and the exports have also decreased because of the numbers. I mean, this has come out in the World Bank report as well, because of the disruptions and the demand for Afghan and for the decrease for Afghan goods. One of the other impacts would perhaps I would say that will have policy and maybe will have some legal implications is that when the government Afghanistan is a centralized, it's a unitary, centralized as a system, and that was actually there was a lot of stress put on it because when cases started appearing in provinces, mainly bordering neighboring countries, first starting with Iran, where most of the cases came through. And then with borders in Pakistan and so forth. So the central government, in a kind of a hurry, dispatched a lot of resources and cash to the provinces for them to address the situation. I think the jury is out on how effective this was, but that was seen as the kind of the only option at that time. And for obvious reasons, there were limited procurement capacity, spending capacity in the provinces, and there were limited options of what they could get in order to address the pandemic. Certainly very limited options in getting new medical equipment, at least more sophisticated equipment and so forth. So there's a lot of, the pandemic has put a lot of stress on the government, on the central, but also on the provincial level, where a lot of calls for reports of vast corruption and mismanagement, and especially on an issue of this nature, where people are perhaps going, are going through some serious hardships, where some very kind of eye-popping in the case of corruption have come up. So all of which has, I would say, further raised questions about, the government's capability to handle the situation. So I think what the impact of this will be is that the legal framework would probably be more flexible in dealing and giving the local governments or the provincial governments more authority, but at the same time requiring more capacity to be built at the local level to address certain situations on and going forward. On the issue of the big economic issues, what the government was.
Sorry, Kawun, if you could just wrap it up, your last observation, please.
Okay, on the legal matters, I think the issues with the questions about force majeure and disputes, what constitutes force majeure. I've heard of this quite a bit coming, but I think that the government trying to address the government, because of the dwindling aid and capacity and so forth, the government pushing more on PPP, I'll say, projects and to boost economic activities. Last point on the coordination, of course, a lot of aid and services dependent in coordination with international institutions, WHO being a forerunner, and this for issues, again, as to who controls which areas to and how do they do it, some disputes between the government and WHO and others. But overall, again, it's the country is going through some tough times. I think the system is being stressed and stretched, and how it will fare in the coming months will be seen. Thank you.
Thank you very much, Kawun, for that sobering assessment. I just wanted to take a second to remind all of our audience members to feel free to type in your questions using the Q&A function, and we will get to those during the Q&A after our presenters have finished their presentation. So now moving to Afghanistan's next door neighbor, we will ask Mr. Ali Sultan to tell us what is happening in Pakistan and the broader South Asian region. Ali, over to you.
Thank you, Matthew. First of all, thank you, American Society of International Law, for organizing this webinar. And I also appreciate very much being on such a distinguished panel today. Now, as far as Pakistan is concerned, let me just first briefly give an overview of the numbers in Pakistan. In terms of the actual number of cases, the numbers haven't been that much, given the size of the population, but that is really a mirage, because the number of testing has been very low. And I think the same can be said about India as well as the rest of South Asia. So not enough testing is a problem across the region, and as a result of that, the numbers that we're dealing with in this region are probably inaccurate, and a correct projection is difficult at this point. And there's always the real danger that perhaps India or even Pakistan could become the next hotspot of coronavirus. So we're really on tenterhooks as far as the outbreak of the pandemic is concerned. And unfortunately, if that happens, then really the region's healthcare system, which has been neglected for decades, is really not up to speed to cope with this unprecedented challenge, which is just which has just come about, unfortunately. So that's the broad picture. And also let me just emphasize here that in addition to the coronavirus pandemic, there are other challenges which have simultaneously gripped the region and also exacerbated the situation, or also taken focus away from attention on coronavirus pandemic. So we see Professor Vivienne also mentioned that there is this emphasis on national security. Now, historically, the South Asian region has been riven with territorial disputes, which just don't seem to find any resolution. And since the last year, India and Pakistan, for example, have been sparring over Kashmir, especially after India unilaterally changed the status in August last year. So there's that constant threat which Pakistan perceives is emanating from India. And of course, India perceives similar threats emanating from Pakistan. So that has spiked up. The coronavirus has not come in the way of these countries sparring with each other. And then, of course, we also had tensions between India and China, which flared up on the border after decades. That has changed a lot of things in India. In addition to that, there are certain natural challenges that we face in this region. Now, after decades, there is a locust attack, which is predicted, which is coming out of the Horn of Africa, and it's predicted to wreak havoc on the agricultural crops in India and Pakistan unless timely action is taken. So there is a real danger that there might be food security issues down the lane if this is not tackled. So there is attention which is diverted to fighting this locust attack as well right now as we speak. Now, the third issue has to do with the monsoon rains which have just started in the region. Now, even today, I was reading that in Hyderabad in India, there were hospitals which got flooded as a result of these monsoon rains. And given that the public healthcare system in these countries is already so stretched and inadequate to deal with the pandemic, any such cases of flooding, making these medical facilities inoperable is, of course, going to exacerbate the problems further. So these are, some further challenges which the region is facing in addition to fighting the pandemic, the coronavirus pandemic. Now, in terms of the law, the first aspect which Matthew mentioned, which has to do with emergency legislation, none of these countries actually declared a public emergency or a health emergency. In fact, Pakistan's constitution does not even allow it to declare a health emergency on the basis of a pandemic. But both India and Pakistan have this sweeping epidemic act, which goes back, would you believe it? It actually goes back all the way to 1898, when the subcontinent was still colonized by the British. So in Pakistan, we still were using variants of that law in various provinces. In India, that law is still the national law. And all the restrictive measures which were undertaken in India and in Pakistan were undertaken as a result of certain provisions that were available in this act, which is dating back to 1898. So what does that say? Immediately, both these countries and all the other countries in the region need to update their national legislation in light of modern IHR, international, international health regulations, which were issued by the World Trade Organization. Now, Pakistan is trying to do that. The government has come up with a COVID-19 ordinance, which is in the process of being passed. And it is hoped that these issues of emergency powers, restricting movement, travel, and so on and so forth during a pandemic would be streamlined as a result of this legislation. So that's essential. And of course, India and Pakistan, both being dualist countries, cannot really give meaning to their international obligations until they translate those obligations into domestic legislation. So that's the first aspect. The second aspect, dealing with economy, trade economy. Now, again, if you look at the nature of the economy, both in India and Pakistan and in other countries in the region, you will notice that a big chunk of the service economy in these countries is comprised of informal workers. Now, these are workers who are not really covered by any legal contracts. They're not covered by any social security nets that exist in patches. So they're the ones who are going to bear the brunt of the hardship during the corona pandemic. So the Prime Minister of Pakistan, Mr. Imran Khan, was always very adamant that Pakistan perhaps could not afford a curfew-like lockdown for a prolonged period, simply because the people in the informal sector would not be able to bear it. So that informed a lot of policy making, which the government ended up doing. And as a result of it, we never really had a full curfew-like lockdown in Pakistan, maybe not for more than a week. So the restrictions have really been eased out because the socio-economic impact of the coronavirus pandemic has been judged by the policymakers to be so acute on the informal economy and the daily wage earners that they're really not willing to take drastic steps as science would demand or as medicine would demand. So that's another challenge which this region is facing and will continue to face. Now, also related to workers, India and Pakistan have scores of workers that were working in Middle East and other countries. So these migrant workers, they were laid off in those countries, and then they also had to come back. And both India and Pakistan's economies relied on remittances from these countries, and that's also taken a big hit. So it's going to, moving forward, the economy in the post-COVID-19 economic world, the economy is going to suffer even further. And yes, as Mr. Kakar also pointed out, the World Bank and the IMF reports are constantly pointing towards a 6 to 8% wipeout of economic wealth in the region, in the South Asian region. So that's drastic. Now, on top of that, in India, we also see, this economic nationalism, this drift towards economic nationalism, especially with respect to China. In response to the border skirmish, what they've done is that they've banned 59 Chinese apps from operating in India. They're not going to allow China to participate in 5G trials in India. Now, there were certain investments that were lined up, Chinese investments that were lined up in India, which India has actually cancelled. So this is something that is going to, this decoupling of Indian economy with Chinese economy is something that we can expect moving forward, and that's going to have a significant impact both in India as well as in the region and also globally. So that's something that needs to be looked at. Okay, since Matthew is calling our time now, I'd just like to make one last point, which is personally very dear to me. That has to do with the right of education, flowing from International Covenant on Economic, Social, Cultural Rights, Article 12. Now, because up to 70% of the population in India and Pakistan, and we're talking about 1.5 billion people, and 70% of those are under the age of 30, and most of them are still in school. Their right to education still stands unfulfilled. Now, as a result of this coronavirus pandemic, since the schools are shut down and many schools either couldn't go to online education learning, or those that did end up going to online learning methods or online teaching couldn't really deliver because online penetration in India and Pakistan is close to 30%. So many students don't have access to these digital platforms that can be used to impart online education. So the right to education, which is critical, if we do not educate people in this region, this population could be troublesome, to put it mildly. On the other hand, if we do educate them, they could be a great resource, not just for the region, but for the rest of the world. So that's the attention I think that I would like to, to draw your attention to as well. Thank you.
Terrific. Thank you very much, Mr. Ali, for your very comprehensive and probing analysis of the problems that Pakistan faces. Initially, in introducing Charis, I was going to say, well, now we're shifting to a very different type of jurisdiction, moving from Pakistan to Singapore. But it's interesting, there's actually commonality there in terms of, perhaps we could say the class dimension. I understand in Singapore, domestic workers have been particularly hit by COVID-19. And recently there was an election in Singapore. I'm curious if the COVID-19 response was part of that discussion there in Singapore. But in any event, let me turn it over now to Charis Tan for your analysis.
Sure, I'll include all of that, Matthew. First, thank you to Matthew and Weixia for having me. Thank you to all the speakers. I feel like I've learned a lot just listening to you. So thank you for your wonderful presentations. Well, first, hello everyone. Good morning from Singapore. I will start off by giving you a feel for what things have been like here on the ground in Singapore, and hopefully talk a little bit about what Matthew mentioned, things like education as well. So first, if you remember, back in late January, Singapore was one of the first countries around the world that was affected by the virus. We had a promising start. We were touted at the time as the gold standard for case detection. That's because Singapore is not such a big country and we have very good and strong government. But one of the, now on hindsight, perhaps not the best advised at the time, but what was the situation was that WHO had issued an advisory that people should not wear masks unless they were sick. And Singapore took that advisory, adopted it, and actively discouraged our population from wearing masks unless they were sick. Now, hindsight is 2020. Of course, now we all know about the dangers of asymptomatic transmission, but at the time, nobody knew. Then the other thing that we got blindsided by, and this was what Matthew alluded to, is our foreign worker dormitories. So in Singapore, we rely on some 400,000 foreign workers. Many of them, and this picks up from Ali's presentation, many of them from India, Bangladesh, Pakistan, and they are living in these huge foreign worker dormitories. I'm sorry to say that conditions can sometimes be cramped. You can have 12 people, 14 people, 20 people in a room. And what happened was that one foreign worker got infected, one cluster, and then the virus just started spreading like wildfire through these living quarters, because they are quite close living quarters. At one point, we had over 1,000, 2,000 cases a day just coming from these dormitories. And that still forms the bulk of daily infections in Singapore today. But thankfully, the Singapore healthcare system is very robust, very strong. I don't think it ever reached a stage whereby it was overwhelmed. So, and the government is obviously very efficient. So we set up sort of community sites whereby those infected could be taken care of where their infections were not so severe. And most infections were not severe because these are young, healthy people. Then this picture is not going to be rare from anywhere around the world. One of the things that started happening was people started going into panic buying mode. So the government then tried to ensure that it could secure and diversify supply lines. Singapore still does not produce enough food to feed our population. It's unlikely we'll ever be self-sufficient. So Singapore got together with some like-minded friends, Australia, Brunei, Canada, Chile, Myanmar, New Zealand, and we released a joint statement to say we will maintain open supply chains. Then things got worse. We had a circuit breaker, what everybody else around the world calls lockdown, but we had a nice term for it. So we all had to work from home, shops and restaurants were closed, people could only venture to the supermarket, and you had to go by yourself, etc. The circuit breaker started being eased on the 2nd of June, but really only on the 19th of June, shops and restaurants started to reopen. Where are we today? Quarter on quarter, the Singapore economy, the GDP shrinks 41.2%. Many economists say this was worse than expected. So that is where we are. People are feeling the heat. Now, then let me turn a little bit to how practice has changed. A little bit about myself. I am a lawyer in private practice, and my practice areas include international commercial arbitration. So that's sort of on the international, private international law side of what Matthew referred to. I also practice investor-state arbitration and public international law. So that's a little bit more on the public international law side, which Matthew again sort of mentioned in his introduction. So what have I been seeing, right? Let me start with some anecdotes. I'll keep it very short because I know we don't have much time. But in one of my commercial arbitration cases, we made an emergency arbitrator application. Phenomenal speed. We had a hearing within 1 week, a decision within 2 weeks. And we did the entire hearing online via Zoom. So that was very smooth. Another of my cases, the rules, the procedural rules in there require a physical hearing, and there's a large number of parties involved. So we might be looking at delay of about a year, maybe more. Nobody can quite predict, but that is an evolving situation that we're grappling with. So we're in a very different world. Some parts of practice, what I call practice, private legal practice, have adapted quite quickly. Some have not. I work in an international law firm, so online collaboration has always been a large part of practice. This is a photo of me and my colleagues grabbing a drink together. So almost all our cases are across office. So this is what we are used to, and this has only increased in significance. As I mentioned earlier, most cases we have been able to accommodate virtual hearings, but this always depends on agreement of the parties, procedural rules, jurisdictional basis, various factors. That client meetings and meetings with experts have moved online and over the phone. We have gotten more adept over time. Law firms, most firms in Singapore have frozen hiring. Some that I've heard of have applied pay cuts. It depends quite a lot on how large the firm is and the particular practice area. So for instance, in disputes, which is what I do, that area of practice has carried on largely unaffected. In some ways, perhaps people might say that's fortunate because we can work from home, even hearings can be conducted online. But obviously where the firm has large corporate practices, transactional, M&A, capital markets, once you have a situation of recession or the economy is affected, you will have that affected more significantly. Now, let me very quickly try to touch on some trends in the cases that we have been seeing. So first, let me take the private sort of international law side, which is international commercial arbitration. In general, I think we might actually be seeing more cases, so an uptick in the number of disputes. Some seem to be genuinely linked to the COVID-19 related disruptions. Some might actually be a bit more opportunistic. we are seeing, number two, an increasing emphasis on interim measures, emergency arbitration procedures, expedited procedures. And why this is so is because as the COVID situation evolves, people want to try to preserve the status quo. So there's a shift in emphasis to this sort of litigation armory, so that people can preserve basically whatever assets or whatever the status is in between parties, right? Procedural timetables were initially affected. Initially, we saw a large number of hearings being postponed or suspended, but then quite quickly, I think people realized this might be the new normal. So then tribunals started to forge ahead and we moved to virtual hearings. Nowadays, quite often a tribunal would set a date for a hearing and it will say if it can take place physically, we will do it physically. If not, we will proceed via Zoom, Blue Jeans, Skype, Microsoft Teams, you name it. Now, investment treaty arbitration and state-to-state disputes in the public international law sphere, I'll just pick up a little bit because this has been touched on by, among others, Professor Chi. Now, one of the things that we are all aware of is that government action lies at the very heart of managing this situation of COVID-19. Many states took unprecedented measures to protect public health, some on the basis of emergency powers, but as Ali also mentioned, some are not, and some even on very old legislation. The measures included shutting down businesses, intervention in certain sectors, industries, nationalization of companies, requisitioning of property, goods and services, for instance, PPE. So against this backdrop, what we have seen is that investors have started to make noises that these measures could violate their rights or have violated their rights. So one question is whether or not these measures could lead to remedies through ISDS, investor-state dispute settlement. Now, given the circumstances, and again, as alluded to previously, states might be able to avail themselves to quite a number of defenses under public international law, right? It includes exceptions for non-discriminatory measures to protect human life or public health, as Professor Chi mentioned. Customary international law provides for defenses such as force majeure, distress, necessity. There's also a doctrine of police powers, which allows a state to take reasonable measures in good faith for the purposes of protecting public health. Events have moved online, such as this one. I mean, for the most part, I really enjoy the fact that we can still have the exchange of ideas and forums online, but I do miss seeing people face to face and catching up. So now, what's the way forward? I don't know, but let me give you some observations. Singapore has a very open economy. Global commerce is the lifeblood of our economy because we are a very small country. So, and we market ourselves as a hub for business, travel, investment. So this will hit us very hard and also has already hit us. We are trying to reopen.
Just be really succinct here, really succinct, Charis, please.
Yep. The Singapore-China travel bubble started since 8 June. Singapore-Malaysia travel bubble starts on the 10th of August. And my last point, elections. Last week, the opposition has won the most seats in parliament since our independence. So this will herald some reflection, I think. I leave that there. Thank you very much, Matthew.
Thank you. That's terrific, Charis, and really fascinating to think through the adaptations that the dispute resolution industry has made under the incredible conditions of the pandemic. So now, last but certainly not least, we have Professor Weixia, who will finish our presentations. Weixia, over to you.
Thank you very much, Matthew, and thank you very much to ASIL as well. And then thanks also to the speakers for your support for the first webinar series organized by Matthew and myself for our Asia Pacific Interest Group. So we had a bit of like split between me and Manjiao in terms of covering of the region. So Manjiao mainly focuses on China, while I will focus on Hong Kong. Well, everyone knows that Hong Kong is a special administrative region of China, of the PRC, well, but it's a very independent legal jurisdiction. in the sense that Hong Kong is a common law jurisdiction within China as well as within the Greater China region. So as Matthew has provided in the introduction, I will first tell you something about the statistics in terms about the impact of COVID on Hong Kong's general economic sector. Well, these days, Hong Kong is currently facing with a third wave of COVID-19, as people have heard about in the news reports. Hong Kong administration has described this third wave of infection as by far the most severe since the pandemic had started. And over the past weekend, on July the 12th, there are 61 people in Hong Kong who were confirmed. This is even more serious than March 2020, where we have a lot of, international students from Hong Kong region coming back from England and United States. Hong Kong has a very unusual year, starting from last summer to this summer. There are three major, what we call the city-changing events within the 1 year time frame. First, last summer, you have the anti-extradition bill movement, and then there's sort of like, tension between the Beijing and Hong Kong tightening up. And afterwards, you have the COVID-19 sort of, impact, which also seriously impacted on Hong Kong's economy. And afterwards, you have the national security law, where Professor Vivienne and Professor Manjiao has also mentioned. Well, in terms of economy, Hong Kong, very much like Singapore, we have a very much service-reliant economy. So if you look at the retail industry like Prada and Tissot, these are the luxuria products and luxuria services, retail giants in the world. They retreated from the Russell Street in the Causeway Bay, which is deemed as one of the most expensive shopping streets and home to high-end fashion brands. In addition, you have seen US-based clothing retailer Gap, GAP, which has very recently announced that they plan to close 5 out of 8 stores in Hong Kong. So this is very serious hit in Hong Kong's retail industry. On the industry of real estate, that Hong Kong's real estate market, the housing market in Hong Kong is super expensive. Well, if you look at some of the observations and then some of those retail and their real estate observation analysis, they say that commercial leases in Causeway Bay and Central dropped by 20% in the first 3 months of 2020. So this is a very serious hit. In terms of the legal and political sort of, public international aspect, you will see that the outbreak of the pandemic has intensified the US-China tensions in all aspects, not only the trade tensions, but also the political tensions. US President Donald Trump has called the coronavirus as sort of the Chinese virus, even more than the Wuhan virus. The Trump administration has announced that they will start to end the preferential treatment for Hong Kong, which you have heard about in the news releases in trade. And then the travel restrictions in response to the new national security imposed by Beijing. There are also a lot of travel restrictions on entering Hong Kong. So you see a huge, massive series of compulsory quarantine for inbound travelers from overseas. In this respect, Hong Kong has passed 2 new legislations. In the past few months, Hong Kong has passed the compulsory quarantine of certain persons arriving at Hong Kong from foreign places regulation, which is Chapter 599C in the Hong Kong legislative system. You have also seen the prevention and control of disease requirements and directions on businesses and premises, what we call the social distancing ordinances requirements that, you need to remain social distances. And then you also see compulsory measures on prohibition on group gathering. This week, we have seen that the group gathering will be limited for 4 people. For a table, for a dinner gathering or lunch gathering, you need to limit it by 4 people per table. Well, in terms of, Hong Kong's interaction with WHO, because Hong Kong is a special administrative region within the PRC. So I do not see that Hong Kong has too much interaction with the World Health Organization, because, its political status and legal status as not a sovereign state. But this is very interesting, as I would alert that back in 2006 to 2017, Margaret Chan served as the Director General of the WHO. And Margaret Chan is a Hong Kong local lady who used to serve as the head for Hong Kong's hygiene department. Margaret was the first Hong Kongese as well as the first Chinese who have been served a major post in an international organization. So my personal view is that it might be a very interesting case study of transnational legal order in the area of public health and supranational institution as a Chinese delegate with a Hong Kong background or Chinese delegate with a Hong Kong identity, CF Tedros handling with the pandemic, which has been accused of being pro-China. So you will see Margaret versus Tedros, which might be a very interesting case study. Well, in terms of sort of, international law impact, my professional background is more on the private international and international economic law and international dispute resolution. So I would just like to supplement what Manjiao, Vivienne, and then Charis has already provided in the terms of, international dispute resolution. For those which have not been mentioned by the previous speakers, I would just like to throw in my personal viewpoints on these issues. Firstly, international arbitration. I would like to mention 3 points. First one, it's the promotion of the online hearing as the new normal for ICA, for international commercial arbitration. Well, we see huge numbers of e-hearing. Actually, I think e-hearing is a must. It's pretty much not an exceptional case, but it's just a normal case. You will see that in the leading regional, what we call the Asia Pacific Regional Arbitration Centers, you see CTAC based in Beijing, headquartered in Beijing, but they have sort of like subsidiary throughout mainland China. You see HKIC based in Hong Kong, Singapore, SIAC. You also see Australian, ACIC. They have all promoted e-hearings. They have both actively encouraged parties to use its e-hearing services, and they have also issued guidelines on virtual hearings. Apart from e-hearings, they have also tried to preserve confidentialities. For example, what I see from HKIC, from the Hong Kong jurisdiction, is that they would use double password services when they are doing sort of, cross-examinations, or sometimes when they are combining mediation within the arbitration procedures. When they use expert services, they will use double password meeting rooms. So this is tried to preserve the confidentiality issues in line with the pandemic incidents. Apart from that, you also see an alliance of the arbitration institutions in the Asia Pacific to combat the pandemic. There's a joint statement issued by a group of leading arbitration institutions in the world, not only in the East, but also in the West. The joint statement was issued by ICC in Paris, HKIAC in Hong Kong, SIAC in Singapore, and LCIA in London. You will see that these leading arbitration institutions in the world, they unanimously has advocated the use of the online webinars as promotion of knowledge exchanges, promotion of their services, the promotion of the online hearings, the reduction of the arbitration fees and costs, and the preservation of the confidentiality in light of the COVID-19. So this is the first issue as I have observed. Second one is about the ICN and global lex mercatoria. So you will see that in terms of global commercial law, like lex mercatoria, international commercial arbitration has been one of the major drivers and major contributors and contributing to global transnational business laws. As Matthew, Manjiao, Ali, Vivienne, and then Charis has mentioned, force majeure has been one of the issues very frequently mentioned in the arbitral cases and hearings these days. You will see that force majeure clauses, they are commonly found in commercial contracts, not only in the common law jurisdictions, but also in the civil law jurisdictions. Hong Kong is a legal hub, because Hong Kong is a common law jurisdiction within China. So you will see a lot of, sort of like cross legal system contracts, cross bilingual sort of, arbitral hearings taking place in Hong Kong, that you would like to have a harmonized sort of perspectives on the use and application of force majeure. In this respect, I would like to quote the British Institute of International and Comparative Law, BICO, which has very recently issued 2 concept notes regarding the effect of the pandemic on the commercial contracts. In particular, the concept note called for a more creative, graded, but nevertheless rigorous approach under COVID-19 force majeure clauses. Yet without prejudicing the underlying need for legal certainty. I mean, legal certainty versus hardship. Now, the third issue, which I think is most controversial in my present, okay, I'll be very quick on that, just about the US litigations against China, especially under the FSIA. Well, for that respect, I agree with the view of Professor Tom Ginsberg at Chicago Law School that it's more political than legal. But in the meantime, I also see the potential of arbitration against China by the WHO or some of other jurisdictions. What I see is that if you want to sue China before PCA, according to the PCA and their other WHO regulations, you need state consent. So China will unlikely participate in the international arbitration, which set out to try its own alleged wrongdoings. This is very similarly applied for litigations against China under the ICJ sort of proceedings. Again, state consent will be required. It's the WHO International Health regulations. They do not allow litigation in the absence of a sovereign state's consent. Thank you.
Perfect. Thank you very much, Weixia. Incredibly complicated case of Hong Kong. You did it justice and then some. So we have about 11 minutes for our Q&A. We have a number of questions here. So allow me to quickly read off and summarize these questions, and I'll try to direct them to the respective speaker. So this one actually kind of, let's start in reverse order here. This is for Manjiao, Ali, and Charis. Since migrant workers are such a large part of the economies of China, Pakistan, and Singapore, what options do migrants have to recover economically? If migrants have suffered economically, such as forced shutdowns of their business, etc., refusals to give salaries, do they have legal redress? Do either of any of the three of you have a response to this question?
Shall I try to say something very quickly? So
Please.
For migrant workers in Singapore, they have continued to receive their salary throughout the circuit breaker in Singapore. They've been paid by their employers, but that's also because there's been massive support by the government. The government has always been saving up for a rainy day, and when COVID-19 happened, the government released budgets of more than $100 billion just to support businesses and employees. Over to someone else.
Thank you, Charis. Ali or Manjiao, any thoughts?
Yeah, well, very short. I think the migrant workers in China refers mainly to domestic migrant workers instead of foreign, like in Singapore's case. For domestic migrant workers in China, the most important thing is that many of them do not have employment contract. So these makes defending their rights very difficult from a legal perspective if they have no contract at all. But of course, even if they have, there are a number of legal redresses going to administrative review is one way, and then administrative litigation is another way. But the problem is that there are some empirical studies showing that if you go to administrative review or administrative litigation, the rate for success in challenging the government is not really very good. So the chances are slim. So basically, I would say yes, they do have legal redresses, but there are a lot of difficulties in reality. So that's this short answer.
Thank you very much, Manjiao. Ali, did you want to add anything?
I agree with both the panelists, and I'd just like to add one thing, that in going beyond the law, I think states should actively include in their policy prescriptions protections for migrant workers on similar lines that Singapore has been able to do. I think that's the need of the hour, and we didn't see that in the case of migrant workers who originally belonged to India and Pakistan but were working in Middle Eastern countries. So they didn't have a lot of legal protections, and ultimately a lot of them have found their way back to India and Pakistan, where now they will need to be reintegrated into the labor force.
Terrific. Thank you very much, Ali. And now moving to a second question. The question is directed to Manjiao and to Weixia. So maybe Manjiao, you could start off here. So the question is whether the measures taken by governments would amount to any breach to treaty obligations, for example, mandatory economic lockdown and some border restrictions. Could investors claim for compensation for any loss caused due to these measures? And also the questioner would like to know whether or how have investment arbitration proceedings been affected by COVID-19? Would the pandemic influence or contribute to the reform of ISDS? And actually, maybe Charis, you also have some thoughts about that. But why don't we start with you, Manjiao?
Okay, sure, Matthew. Well, yes, the answer to the first question is yes, it is possible for foreign investors initiate investment arbitration against China, and similarly, Chinese enterprises can rely on Chinese foreign BITs to initiate arbitration against a foreign state. But the thing I believe we already mentioned, there were a number of clauses in treaties and in public international law. Charis has also mentioned. So those would be the legal grounds for these arbitration. But the thing is that for countries, I believe taking measures to combat COVID is quite urgent, and that would give states, I would say, more weight in if there is an arbitration case. But I'm not saying that investors would not have a chance to win the cases, but they will face more difficulty than usual time in dealing with this. And as to the second question, how will this influence in a way the ISDS reform? Well, the current ISDS reform focus on the structural discussion, basically what kind of a treaty model the international community would like is that the BEPS model of the OECD trade erosion and double taxation treaty, or the Mauritius treaty model, or more. We do have some suggestions and proposals, and it seems that countries are diverse with regard to this. But frankly speaking, I don't think the pandemic would substantially influence this ISDS reform at this point of time, because as far as structure is concerned, it's more like what state would like future ISDS to be. So that's the quick question.
Perfect. Thank you so much, Manjiao. And Weixia, do you have any thoughts?
All right, thank you. Thank you, Matthew. I would just follow up with what Manjiao has just discussed. I think it's very likely that, foreign investors, they will sue the Chinese sovereign state in the ISDS or investor treaty arbitration, and vice versa, that the Chinese investors, they can also sue foreign states for their allegedly mishandling of the COVID-19. But what I'm worrying about is the enforcement. Well, even though you have overcome all the technical sort of, technical difficulties and political difficulties in suing against China in terms of, the litigation standing, evidence issues, whatever. At the end of the day, when you would like to enforce in the war and against the Chinese sovereign state, you know that the PRC has the official stance that they have adopted an absolute immunity stance, which is very different from the American stance, which is what we call as the relative immunity. The most recent PRC stance on the state immunity, I think the case is, it's illustrated by the case Kango FG Hemisphere case. This is a Hong Kong case. But in that Hong Kong Court of Final Appeal case, they have sought clarification from the National People's Congress Standing Committee that the PRC is very affirmative in continuing to apply an absolute immunity stance in all its state immunity cases. So I'm very worried if any of the parties, whether this is foreign parties or even sovereign or state-owned enterprises parties suing against the PRC sovereign state, whether at the end of the day they will be able to enforce the war against China. Thank you.
That's great. Thank you very much, Weixia. And Charis, I'm sorry I'm not going to be able to include you with this question because there's other questions. I want to make sure we get to them. So this question actually is for Vivienne. So the question is, share your insights on Australia's position in tackling the current impasse in the WTO appellate body, and if possible, how narrowly, expansively political offenses might have been interpreted in the Australian jurisprudence. So a little bit maybe outside the core issue of the COVID-19, but if you could address that in 90 seconds, that would be fantastic.
Well, in relation to the first one with the WTO appellate body, there's been a lot of discussion of this before COVID-19, although it doesn't get much airspace during COVID-19. But Australia's position is, I think, shown by the fact that it's signed up for the multi-party interim appeal arbitration agreement. Australia is very strongly committed to multilateralism and the efficient functioning of the WTO, and very dismayed by the fact that the appeal procedure has broken down. So obviously what they would want is a functioning appeal tribunal, but in the meantime, they will take advantage of this new body to the extent possible. In relation to political offences, look, political offence is never really a defined term. Essentially, it has to be an act against a government. So there's an Australian case where extradition to the US was refused for a member of the Tamil Tigers who was conspiring to buy weapons on the basis that the US essentially had made this an offence which was political in nature because it was related to the government, and therefore it was not an extraditable offence. More likely in Hong Kong, because political opinion or persecution or prosecution on the basis of political opinion is also something which is a grounds for resisting extradition. It would be quite easy, I think, for a lot of the Democrats and the activists to show that they were being prosecuted on the basis of an expression of political opinion, such as the independence of Hong Kong or something of this kind. But of course, the advantage of suspending the treaty is that you don't then have to go to the defences or the exemptions, because there's no mechanism for actually extraditing them back to Hong Kong.
Thank you very much, Vivienne. So we have about 30 seconds left, and I want to ask a question to Kawun. We've talked a little bit about the decoupling with China now as a result of COVID-19 and other political international relations tensions with China. So Australia, India, obviously the US. Is there also a coupling going on vis-a-vis China and in terms of Afghanistan's economic and political relationship with China? And obviously this would also apply to Pakistan. Unfortunately, we have very short amount of time, but is there any way you could give us your briefest assessment of whether or not we could see a kind of coupling in addition to this decoupling that's happening elsewhere?
My brief answer would be that I think China has been a kind of an important neighbor for Afghanistan for a long time, and I think with the expected return of the U.S. forces and others, and the interest that actually of the regional country, and I think China being a very important country in the region, I think Afghanistan would be even promoting its ties closer with China and others in the region.
Perfect.
I hope that answers.
That was excellent. Thank you, everyone, so much. We are out of time, but again, I want to sincerely express my gratitude for everybody for joining this call, for sharing your expertise, your knowledge, your insights, and to our audience members, please stay tuned for subsequent webinars and hope to include more people, more questions, and more conversations. Again, thank you, everybody. Take care and stay safe.
Thank you.
Thank you. Thank you.
Thank you, everyone.
Bye.
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 Bye-bye.
Thank you. Bye.
Bye.
Thank you.